Hello, good morning. On behalf of Gender Ideal, welcome. I'm Flory Wilson. I am the founder and CEO of Gender Ideal, and I'm delighted to have you join us for this sixth session in our LinkedIn Live series. This series explores the concepts covered in the Ideal 12 assessment, which is a tool that Gender Ideal launched in March of 2022 that is designed to be a first step for companies to benchmark their performance on 12 core practices that have impact on gender equity in the workplace. We hope you walk away from each of these conversations with the insights you need to be an advocate inside of your organization on why and how to begin implementation of these practices. Links to this video and the other videos from this series, as well as additional resources, can be found on the resources page of our website. We encourage everyone on this call or watching the video to participate in taking the Ideal 12 on behalf of your organization. Once you've submitted the Ideal 12, you'll receive a score out of 12 points, access to a benchmark report, and then we encourage you to make a commitment to improve on any one of those 12 impact practices. You can learn more about the Ideal 12 on our website, www.gender-ideal.org. I'm really looking forward to this conversation today with Jen Liu. I've known Jen for, more than a decade now. And so I know all of the impressive work that she has done over the course of her career. She is currently the managing partner of Liu Peterson Fisher, an employment and civil rights firm based in the San Francisco Bay Area. At her firm, she represents employees in workplace disputes, including in gender discrimination and sexual harassment cases. So let's go ahead and dig in. There are going to be two topics that we're covering today on this call. The first is forced arbitration, which is usually written into an employment contract as the mechanism used to resolve complaints about discrimination and harassment. And then the second issue is using non-disclosure agreements or NDAs to prevent involved parties from sharing details about the resolution of discrimination and harassment claims. So let's go ahead and tackle forced arbitration first. So Jen, let's just kind of make sure we understand the terminology and what we're really talking about. Can you tell us what arbitration is and what is forced arbitration in this context?
Thank you, Flory, for inviting me to join you today. This is such an important topic, and it's really great to have the opportunity to talk about this to people who may not be lawyers and may not be familiar with this topic. So starting off with arbitration, most everyone knows what litigation is. You have a dispute, and to resolve the dispute, you go and you file a complaint in court to begin a lawsuit. Arbitration is one major kind of alternative to litigation, and it falls into this general category of procedures called alternative dispute resolution. The other major one is mediation, which in a nutshell is typically voluntary, non-binding, a non-binding discussion with a third party neutral who's a mediator who tries to help the parties agree to a resolution. Arbitration is different. Arbitration typically arises in the employment context through a forced arbitration agreement. And what many employers do is they require or ask their employees to sign an agreement. It's either an employment agreement that has an arbitration provision in it, or it is a freestanding arbitration agreement that requires them to forego their right to go to court if they have an employment dispute and requires them to go to arbitration. So what is arbitration? It's a little bit like mediation in that you have a third party neutral person, the arbitrator, but it is binding. So you go to arbitration, and it's like an abbreviated form of litigation. You file a document that is a lot like a complaint, which starts a lawsuit. But the idea is, and the reason why employers favor it is, it's believed to be a faster and cheaper way of adjudicating disputes. Most plaintiffs and attorneys who represent employees in these kinds of cases disfavor arbitration because you do not have the same access to procedural mechanisms and discovery that you would get in court. It's one of a couple of reasons that I'm sure we'll go into on this call. And after months in arbitration, you go to a hearing, which is a lot like a trial. And at the end of that, the arbitrator gives you a decision. And for practical purposes, those decisions are final. There is not the same mechanism to appeal an arbitrator's award. They can only be overturned in the most narrow of circumstances. And in fact, I don't think I have ever heard of anyone who has had an arbitration award overturned. So you get your decision. Oftentimes, it appears to be very different than the outcome that someone might have gotten in court in front of a jury, and yet there is no real way to effectively appeal that.
Okay.
Finally, one of the biggest differences between arbitration and court is when you file litigation, all those documents are generally available to the public and open to public scrutiny. Arbitration tends to be private, which is one of the reasons why it is so problematic.
Yeah. Okay. So that so the main difference is you can't appeal the decision, and it sounds like it's a streamlined process where there's kind of less inquiry into whatever the matter at hand is, and whatever discovery does happen, it's all kept private. So this information is never publicly accessible.
Typically.
Okay. So I can understand then why an employer would have a preference for using arbitration rather than litigation. And yet at the same time, it does feel like there's kind of now this shift away from some of these practices. So can you tell us why? Well, let's first start. And you've already done this a little bit, but if you want to elaborate, tell us why forced arbitration is harmful for employees. And then let's look at it from the other side. Why could forced arbitration also be harmful for employers?
Right. It's harmful for employees because it prevents unlawful workplace behavior from coming to light and from being effectively addressed by a court. When employees are forced to arbitrate their cases, they oftentimes, for the reasons that I just touched on, don't have access to the same kinds of avenues to get information. They don't have the same ways to bring the issues that they're targeting to light publicly. And there is a lot of evidence that the awards in arbitration tend to be much lower than what juries typically award. And so for employers, a lot of employers have adopted arbitration programs essentially to reduce costs, because there is a tendency to view some of these employment issues as potential liabilities, as opposed to indications that something's not going right in the workplace. And I think when you look at reports of employment discrimination and retaliation and sexual harassment in the workplace as solely sources of potential liability that you want to try to minimize, you might minimize that cost to your business, but you're not eradicating unlawful and unfair behavior in your workplace.
Yeah, and so you might be minimizing the legal cost to your business, but when you think about other potential costs, higher than average turnover, employees leaving, lower productivity because employees don't really feel invested in or valued, there are other costs that maybe they're kind of ignoring.
Absolutely.
Through a short-sighted lens. Are there any reasons though why today an employer would say we're going to stop using forced arbitration? Like, have you seen kind of the pattern or the shift away from forced arbitration driven by employers, or is it purely driven by? Okay, let's
For sure. I think that there there are a significant number of employers who don't employ forced arbitration because they believe that it's wrong. Silencing employees and taking away their right to go to court to raise important issues of discrimination, harassment in the workplace is wrong, some employers believe. And that, I think is a wonderful reason not to have these programs. I think another reason why some employers have eliminated this practice is for a more utilitarian reason. A lot of arbitration agreements, in addition to requiring employees to waive their right to a jury trial and waive their right to go to court, they also waive their right to participate in a class or collective action. And so let's say a company is not just discriminating against one employee of a protected characteristic. Let's just say gender discrimination. Let's say it's a policy or practice that impacts women across the company. With an arbitration agreement that includes a class waiver, not only can they not go to court, they cannot participate or bring a class action in order to address a larger problem that impacts other women. Mm-hmm. And in other areas of employment law where employees have faced class waivers, attorneys have rounded up lots of individual arbitrations and filed them against the employer with the idea that, okay, employer, you don't want us to bring a class action, you want us to bring an individual action only, then we're going to give you exactly what you've asked for, and file dozens, hundreds, or more individual arbitrations. And the reason why that can be an employer's worst nightmare is, in order to be enforceable under California law anyhow, and laws of, I think, most if not all of other jurisdictions, the employer cannot make arbitration more expensive than going to court would be. So how it typically works is, if you want to start the arbitration, you have to pay an amount that is similar to what you would pay to start a complaint in court. And that is where the employee's costs end. And after that, the employer has to pay all of the arbitration fees, and it can be very expensive. And so it's this interesting rationale where the sort of heaping of individual costs upon individual costs of these individual arbitrations is an economic reason why a lot of employers have moved away from it. But I think especially here in Silicon Valley, a lot of employers have said, we don't want to employ forced arbitration agreements, or we'll have an arbitration program, but we'll make it voluntary and we'll allow people to opt out. That's another really interesting approach because we think it's the right thing to do.
Uh-huh. Mm-hmm. Okay, that's super helpful and interesting. And I do feel like, we're in this period where it feels like the shift is kind of towards employers recognizing how important it is for employees to feel valued, supported, and heard. And so, that I think is on its own, setting aside the economic arguments, but is probably a compelling reason for a number of employers to want to move away from that practice. Okay, let's shift now to using non-disclosure agreements. So what is an NDA, and how do employers, or how have employers historically used them in these situations?
Right. So non-disclosure agreements are essentially agreements that prevent, in this context, are agreements that prevent an employee from disclosing some kind of information about the employer, about the employment experience, or specifically the alleged unlawful acts that the employee raised to the company's attention. And so it's a form of a confidentiality agreement more broadly. And there are also non-disparagement provisions, which are in a narrower but still oftentimes insidious form of an agreement where an employee cannot say anything disparaging, which means nothing bad, whether it be true or false. And historically, non-disclosure agreements and non-disparagement agreements have been part and parcel of severance agreements. And behind the scenes, what happens in a lot of cases is, after an employee believes that they have been treated unlawfully because of discrimination or harassment, so many of those cases settle privately. And this is, I think, a struggle that so many of us who represent employees have experienced over the years, which is, you have a client who has experienced unlawful treatment. Let's use the example of sexual harassment, because that's one that has been most in the news, that people are very familiar with. Let's say that other people have been impacted by, perhaps it's even sexual harassment by the same perpetrator. But if your client wants confidentiality, if your client needs care because they've been traumatized or injured, or both, from their experience, your role as the attorney is to get them their desired outcome, and sometimes that is compensation. And what has historically happened is a lot of employers have offered compensation in exchange for silence.
Mm-hmm.
And most of us who do this kind of work went into this area of law to fight discrimination and injustice in the workplace. And but there's no doubt that secret settlements allow unlawful behavior to persist in the workplace. Harvey Weinstein is the probably the best and most well-known example of that. When case after case of egregious sexual harassment and assault, even rape, can be swept under the rug with a secret settlement, that is a problem. Even if, in each individual case, it seems right for that client to get compensation so they can recover and move on from the experience, it is bad for society. And it's really, I feel very fortunate to be in a state like California that has really been at the vanguard implementing state legislation. And I know, that's on the agenda to talk about, but California has really done some really innovative and powerful things to its legislation to protect employees who have experienced this kind of treatment, to protect their right to talk about what happened to them. And there's no doubt in my mind that that will lead to greater attention to these issues and make it harder for companies who might otherwise want to sweep these things under the rug to do just that.
So let's talk about that legislation. Can you tell us a bit more what prompted California to introduce this legislation? And I believe they've passed it now, and I think a number of other states have also introduced it, and maybe it's passed in a few other places. And how is it designed to protect employees, and what are the impacts then on employers?
Yeah. Well, so this all really started happening after the Me Too movement became sort of exploded into public view. And once people realized all these horrendous things that had been happening in the workforce all along, everyone got justifiably really upset. And that has opened up an entryway to barring employers from using confidentiality agreements, non-disclosure agreements, non-disparagement agreements, from silencing people who believe that they've experienced unlawful conduct, discrimination, harassment, retaliation in the workplace. First, it was only the initial legislation, both on a national level. The very first piece of legislation that I recall was one that actually protected women in the military in cases of sexual assault. So talk about like a narrow sliver. There was a terrible, horrifying case of a woman who was brutally assaulted by a defense contractor abroad. And that was the genesis for this bill that had been sponsored by then Senator Al Franken. I'll leave that to the side. No commentary on that. But that was one of the first bills to protect the right of women who've experienced sexual harassment or assaults to proceed in court instead of forced arbitration. And once Me Too happened, California implemented a bill called STAND, which is the Stand Together Against Non-Disclosure Provisions Act. Something like that. STAND is the acronym. And that prevented employers from imposing confidentiality or non-disparagement provisions on employees from talking about the underlying acts of sexual assault, sexual harassment, and gender discrimination, but only for those protected characteristics. And so if you experienced harassment or discrimination because of your race, because of your sexual orientation, because you had a disability, those were not included. And so it was progress, but incomplete progress. Yeah. So that the STAND Act, I think it was passed in 2018, went into effect in 2019, I believe. And then more recently, there were 2 Black female employees at Pinterest who engaged in a lot of public-facing commentary of their experience at their company. And they were very active in working with state legislators to implement the Silence No More Act. That one was passed last year, went into effect this year, and in short, expanded these prohibitions on non-disparagement, non-disclosure provisions to protect all the categories that are protected by our discrimination law in California, the Fair Employment and Housing Act, which we lawyers call the FEHA, or FEHA for short.
So what if though a victim wants to stay private? Can they opt to do that and not talk about it? I guess it sounds like in that scenario, it's their decision, not part of a settlement agreement, right? That's like the critical distinction?
Yeah, the law does have a carve out for when the employee is the one who is seeking the confidentiality. And there's also a part of the newer law, the Silence No More Act. There's also a provision. Companies can still have non-disparagement provisions, but if they use a non-disparagement provision, then they still have to include essentially a disclosure that says nothing in this agreement prevents you from talking about the allegedly unlawful things that you experienced.
Okay, so there's a carve out.
Mm-hmm.
Yeah. It seems very clear to me the benefit for employees of this new legislation. How are employers responding to it?
I've seen really the whole spectrum of responses to, and of course, in my practice, we tend to see the companies that are taking a more obstinate course to these issues. Otherwise, if they didn't have a dispute, the employees wouldn't necessarily be calling a lawyer, right? And so, I do see a somewhat skewed cross section of the cases. But there are a lot of companies who I think realize that forced arbitration programs have the effect of silencing employees and covering up unlawful behavior that is frankly not good for business. And what oftentimes ends up with companies happening in companies that don't deal with unlawful discrimination and harassment in the workplace is that people leave. And there's increased turnover, and there is particularly higher turnover amongst the people in those protected categories who are most impacted by the behavior. And so in some contexts, that's women. In very many contexts. In other contexts, it is employees of color.
Okay, that makes sense. So let's then you've done a wonderful job kind of laying out what forced arbitration is, why it's harmful for employees, why it's also harmful in instances for employers. Same thing with non-disclosure agreements. So let's then turn to this next question. And I should say, the way we address this in the gender ideal assessment is we encourage companies to put a policy in place that says they've eliminated the use of forced arbitration and they've eliminated the use of non-disclosure agreements when settling matters of discrimination or harassment. What is that always the right approach? What are some of the tactics that an organization should think about when they want to kind of codify, look, we want to protect our workers and we want to create a work environment where people feel safe and supported to come forward with any potential concerns or allegations? What should a company do?
Right. I think any company that truly wants to eradicate discrimination or retaliation and harassment in their workplace should never have a forced arbitration policy, period. There is no reason to do it other than to reduce liability and to reduce distraction from employees that are raising these concerns. And there are a host of other ways that employers have always treated these issues and that don't involve forcing employees to give up their right to go to court and speak out about their experiences. It's not necessary. So there's also a whole range of things. And I'm sure, the Ideal 12 has a lot of specific recommendations on, for companies that truly do want to address these underlying issues. It goes beyond simply dispute resolution.
Right.
How are you fostering the right environment for your workplace? How are you dealing with concerns? Do you view employee complaints as simply potential liabilities, or as issues that need to be explored and potentially resolved?
Yeah, we have we have a whole section focused on inclusion and creating cultures of belonging. So there's a lot covered there. Then we have a section that talks about benefits and policies, and there we have questions around whistleblower policies. Do you have are you clear about if a matter is raised, how it will be resolved, and how a potential kind of violator of your organization's discrimination and harassment policies will be dealt with over time? I mean, that's the other thing I think that's really just been astounding these last couple of years, is we find out it's not often one person doing this once. It's often the same person doing it over and over again.
Very, very often.
And so how is an employer assuring their employees that when that type of pattern surfaces?
Absolutely. One other thing I wanted to add on to that is, organizations that really want to do right by their employees, stamp out discrimination and other kinds of unlawful behaviors, unfair behaviors in the workplace. One thing for employers to look at is the kinds of agreements that they are asking their employees to sign. And so, I oftentimes see contracts that go well beyond what is permissible under California law. Sometimes it's issues that don't directly touch on discrimination and harassment, right? Sometimes it's, an unlawful non-compete or an overbroad prohibition on being able to solicit former employees or former clients. But what those cases illustrate is that if a contract says you can't do it, even if it's not enforceable, even if it's overreaching, that is going to it's going to chill employees' behavior because they're going to be worried about being sued. And unfortunately, employers will just keep doing this until someone holds them accountable. And there are a number of really innovative cases that have been brought on behalf of employees, saying this employer has illegally asked us to sign these unlawful contracts that don't comply with the law, that go too far, that silence and prevent employees' ability to talk about things that they're lawfully protected in their ability to do. But absent those kinds of cases, it's really hard to catch when this is happening, because asking employees to sign employment agreements or severance agreements, all happens, generally speaking, privately behind closed doors.
Yeah. Well, and doesn't it usually, or I should say the majority of the time, that happens even before you've accepted a position, right? I mean, this happens as you're doing. Yeah.
Very often. Yeah. And, one thing that some of the new laws do, however, is to prevent employers from requiring their agreement to arbitrate or waive other rights as a condition of employment. And so legislatively, we're making progress. We're making it more difficult for employers to force employees to trade away their rights in order to just get the job and get in the door. When, frankly, people, when they go into a job, they're excited. And if they negotiate anything, it's the money. Or, if it's an employer that offers equity, the equity. People rarely even pay attention to the non-monetary issues, much less negotiate them. And people aren't paying attention to these things until something goes wrong in the workplace and they realize that they've already given up their right to talk about what has happened.
Yeah. Wow. So, okay. So in this tight labor market, especially though, we should put the alert out that people should really be reading those contracts before they sign them, before they accept the job, and X out those sections that you're not comfortable with, right? I mean, is that like an employee can do that, right? And say, I'm not going to read these.
Absolutely. Yeah. Not insignificant portion of my practice is negotiating employment agreements. And oftentimes we'll take a look at it and, we'll redline it to say, we're not going to agree to this, and we're going to modify this in this way, and it goes back and forth until you reach an agreement that both sides are comfortable with.
Yeah. And then beyond that, and just to summarize, because we are at time, but it sounds like, the trend is, tell me if I'm summarizing this correctly. Arbitration isn't always a bad thing, but it needs to be something that an employee and an employer are voluntarily opting into. Is that right? Or would you say no, arbitration's always a bad thing?
I wouldn't say that. What I would say is, I'd point to other areas besides employment where parties use arbitration. Commercial arbitration, parties where there are equals involved in business disputes. So if business A, business B get into dispute, it goes badly, both of them agree to go to arbitration. That's fine. They wanted to go to arbitration instead of court because it's cheaper and faster, and both sides agree that is in their interest. Then that's a wonderful thing. The problem with employment arbitration is that it is always, the arbitration agreements are virtually always signed pre-dispute, when people aren't paying attention to what they're signing and they don't realize that they're ever going to have claims. They think nothing's going to go wrong. And I don't think I've ever seen a case where an employee experienced this mistreatment, went to the employer, and then agreed, oh yeah, let's go to arbitration instead of litigation. I'm sure it's happened, but I mean, the 99% plus probably of cases, it's pre-dispute arbitration agreements being signed. And so it's the forced nature of arbitration that is so insidious.
Yeah. Okay. That's great. That's helpful. And then on the non-disclosure agreement side, it sounds like that's just no longer an acceptable component of a settlement at the end of litigation or arbitration, to demand a non-disclosure and a non-disparagement agreement. Is that right?
Yeah, absolutely. And under many circumstances that are addressed by these new laws, it's not even an option anymore. And that is wonderful, because in the past, where when it was possible, it almost always got negotiated into the agreement. And now when we're representing people in these cases, we can simply say, we can't even do that. So let's not even talk about confidentiality. Let's not talk about non-disclosure. And that's good for our country.
Yeah, and good for workers. And one of the things, Jen, we can do, we can add into the resources section is links to other articles or databases that are recording which states have passed these laws and where the legislation's been introduced. I think that's like a helpful thing for people to keep track. I know I've actually talked to a couple heads of HR who didn't even know about this legislation, and they have operations in some of these states. So I'll just put a little pin in that. But if you have, databases or other resources, we can share those afterwards.
Definitely.
And I just want to say thank you so much for your time today and your expertise. You have I'm sorry we didn't have time to talk about some of the cases that you've been involved in, because you've had a huge impact on this topic, but really grateful for your time and for sharing your thoughts with us.
Well, thank you so much, Bori. This is really wonderful to get to catch up with you and talk about this issue.
Great. Have a good one.